When a police officer looks at you and says, "You are not under arrest, just come with us," almost every person does the same thing. They go. Because "not under arrest" sounds like good news. It sounds like the officer is being reasonable. It sounds like cooperating now will make everything faster and easier and less serious than it would be if they refused. Here is what almost nobody knows. The moment you voluntarily get in that police car or walk into that station without being placed under arrest, you have made a legal decision with consequences that most people never see coming, because voluntary in a police encounter is not the same as free. And the rights that would have protected you the moment you were arrested do not automatically follow you into a voluntary situation. You just walked yourself into an interrogation room with fewer protections than you would have had in handcuffs. Today I am going to show you exactly what is happening legally when an officer uses that phrase, why the word voluntary removes protections most people assume they have, the Supreme Court case that draws the line between voluntary accompaniment and custodial interrogation, and the exact words you say before you take a single step. Words that force the officer to tell you exactly what your legal situation is before you make a decision you cannot take back. Hit subscribe right now because this channel exists to close the gap between what you are told in a police encounter and what is actually happening legally in that moment. Share this with one person before this video ends. Someone who would hear those words and go, "Because not under arrest" sounded like safety. That person is exactly who this video is for. Here is the reality that most people are never taught. When you are formally placed under arrest, specific constitutional protections attach immediately. You must be read your Miranda rights before any custodial interrogation begins. You have the right to an attorney, and that right must be honored before questioning proceeds. Anything said during custodial interrogation without those protections can potentially be challenged or suppressed. But when you go voluntarily, when no arrest has been made, and you are simply accompanying an officer to a location of their choosing, the legal framework is different. Courts have consistently held that a person who goes to a police station voluntarily and is free to leave is not in custody in the legal sense. And because they are not in custody, Miranda protections do not automatically apply to the questioning that follows. This is the gap. You go because they said you were not under arrest. You answer questions because nobody read you your rights, and you assumed that meant you did not need to worry. And every answer you give in that voluntary context, every explanation, every detail, every attempt to appear cooperative, is fair game as evidence because you were not in custody when you gave it. The Supreme Court addressed this directly in Oregon versus Mathiasen in 1977. A suspect was invited to come to a police station for questioning. He was told he was not under arrest. He went voluntarily. He was questioned. He was allowed to leave afterward. The court held that the interview was not a custodial interrogation. Miranda warnings were not required. The confession obtained during that voluntary interview was admissible. In plain English, not under arrest plus come with us plus you went equals no Miranda, no automatic right to counsel, and everything you say is on the record. The question you need answered before you take a single step is not whether you are under arrest. It is whether you are free to decline. Those are two completely different questions, and only one of them tells you what you actually need to know. Here is what the bad way looks like. Officer approaches at the end of a traffic stop, or at your front door, or at the edge of a parking lot and says, "We would just like to ask you a few questions down at the station. You are not under arrest. This is totally voluntary." Person goes, sits down in a room, answers questions because nobody read them their rights, and they believe that means this is informal and low stakes. An hour later, they have given a detailed account of their whereabouts, their relationships, their recent activities, a detailed account that an officer has been writing down while nodding sympathetically and saying things like, "I understand," and that makes sense. The person leaves. They were not arrested. They feel like it went fine. 3 weeks later, their attorney is looking at a case built almost entirely on the voluntary statement they gave in that room. Here is what the good way looks like. Officer says, "We would just like you to come with us to ask a few questions. You are not under arrest." Before a single step is taken, the person says this calmly and clearly. "Am I free to decline and leave right now, or am I being detained? I need to know my legal status before I go anywhere." That question does something nothing else in that moment can do. It forces the officer to declare the legal reality of the situation before any movement occurs. If the officer says you are free to leave, you now know this is genuinely voluntary. You can choose to go, or you can choose not to. If you choose to go, you go with full knowledge of your legal situation, not under a false impression created by the phrase, "not under arrest." And before you go, you say, "I am willing to speak with you, but I would like an attorney present during any questioning. If the officer says you are not free to leave, they have just told you that you are being detained or under arrest, regardless of the words they used 30 seconds ago. At that point, Miranda protections should attach, and you say immediately, "I am invoking my right to remain silent, and I want an attorney present before I answer any questions." Either way, the one question you asked before you moved gave you the information you needed to make a real decision with your real rights fully visible to you. Drop a comment right now and tell me, have you or someone you know ever gone to a police station voluntarily because an officer said you were not under arrest, without knowing that voluntary and free have different legal meanings? Yes or no? I want to know how many people this scenario has touched. If you are still here, hit the like button right now, because what comes next is the piece that makes the voluntary trap work so effectively, and understanding it is what makes you immune to it. Here is why the not under arrest framing is so specifically effective. Arrest carries a specific feeling: handcuffs, rights being read, the understanding that things are serious. When an officer tells you that you are not under arrest, they are specifically removing that feeling from the equation. The situation does not feel serious. It does not feel like the kind of moment where you need a lawyer. It feels like a conversation, like cooperation, like the reasonable thing to do when you have nothing to hide. That feeling, the absence of the arrest feeling, is exactly what makes people go. And it is exactly what removes the protections they assume they have, because they do not feel like they are in an arrest situation. Officers are trained to use words that shape the feeling of an encounter. Not under arrest shapes the feeling. Just a few questions shapes the feeling. This will only take a few minutes shapes the feeling. Come with us shapes the feeling. Each phrase is designed to make a serious legal situation feel informal, cooperative, and low stakes. And informal, low-stakes situations are ones where people talk freely without thinking about attorneys or rights or what goes on the record. The one question you ask, "Am I free to decline and leave right now, or am I being detained?" cuts through all of that shaping. It asks for the legal reality underneath the feeling. And the answer to that question, whatever it is, tells you what the feeling was designed to prevent you from asking. Here is what to do in the minutes before any movement happens, regardless of how the officer answers. First, you ask the question, "Am I free to decline and leave right now, or am I being detained?" You wait for a clear answer. Second, regardless of the answer, you say this, "I am not going to answer any questions without an attorney present." Whether you ultimately go or not, whether you are free to leave or being detained, that invocation is on the record before you are in any room answering any questions. Third, if you are going voluntarily, because you have chosen to cooperate with full knowledge of your situation, you say this before entering any room. "I want it noted that I am here voluntarily. I have not been arrested, and I am invoking my right to have an attorney present during any questioning." Then you sit down and you say nothing further until counsel arrives. Those 3 steps apply in every version of this scenario. They work whether the officer intended the voluntary framing as a manipulation or as a genuine statement of your freedom. They protect you in the version where you are actually free to leave, and in the version where you were never free to leave at all. Let me tell you about Sandra. Sandra is 44 years old, lives in Florida, and was approached by 2 detectives outside her workplace on a Tuesday afternoon. They said they were looking into a matter involving someone she knew and would appreciate if she could come answer a few questions. They told her clearly that she was not under arrest. It was entirely up to her. It would only take about 20 minutes. Sandra went. She sat in a room. She answered questions for an hour and 40 minutes because nobody had read her rights, and she assumed that meant she was in a casual conversation, not a documented interrogation. She explained her relationship with the person in question. She described specific conversations she had with them. She gave a timeline of events. She was never arrested that day. She drove home. She thought she had helped. Her attorney, consulted weeks later when the situation developed further, reviewed the detective's report. It contained a detailed account of Sandra's voluntary statement. It was accurate. Sandra had said everything in it. Her attorney's assessment was that the statement significantly complicated their position, not because Sandra had confessed to anything, but because the details she provided, offered freely in a conversation she believed was informal, had been woven into a narrative she had not intended to contribute to. Her attorney told her what I am telling you now. Not under arrest does not mean not on the record. Voluntary does not mean protected. The absence of handcuffs does not mean the absence of consequences. One question asked before she moved would have told her what kind of situation she was actually in. And whatever the answer had been, she would have made her decision with full information instead of a feeling. Sandra now knows the question. After this video, so do you. There are three cases that make everything in this video legally exact. The first is Miranda versus Arizona from 1966. The Supreme Court established that before a custodial interrogation, a suspect must be informed of their right to remain silent, that anything said can be used against them, and that they have the right to an attorney. These protections are tied to custody and voluntary accompaniment to a station, where the person believes they are free to leave, has been held not to constitute custody in the relevant legal sense. The second is Oregon versus Mathiasen from 1977. The court held that a voluntary, non-custodial interview at a police station does not require Miranda warnings. The suspect was told he was not under arrest. He came voluntarily. He left voluntarily. No Miranda. Statements admissible. This is the foundational case for the legal gap that the not under arrest framing exploits. The third is Berkemer versus McCarty from 1984. The court held that the roadside questioning of a motorist, detained pursuant to a traffic stop, does not constitute custodial interrogation. But the court also established the framework for what custody means, the key question being whether a reasonable person in the suspect's position would have felt free to decline the officer's requests or otherwise terminate the encounter. That question, whether a reasonable person would have felt free to leave, is exactly what you are asking out loud when you say, "Am I free to decline and leave?" You are making the legal test explicit in real time. When you understand these three cases together, the not under arrest phrase stops being reassuring and starts being a question about what is actually happening underneath the words. And you now have the sentence that asks it. Here is the complete recap of everything you now know. Not under arrest and free to leave are two different legal statements. One tells you what has not happened. The other tells you what your actual options are. You need the second one before you make any decision about going anywhere. Before any step is taken, you say, "Am I free to decline and leave right now, or am I being detained?" You wait for a clear answer. That answer tells you your legal reality. Regardless of the answer, you say, "I am not going to answer any questions without an attorney present." That invocation is on the record before you are in any room. If you go voluntarily, you state upon entering, "I am here voluntarily, I have not been arrested, and I am invoking my right to have an attorney present during any questioning." Then you say nothing until counsel arrives. The goal is not to obstruct. The goal is to know what situation you are actually in before you make a decision you cannot take back, and to make that decision with your rights fully visible, not under the impression created by two words designed to make you feel like you do not need to think about them. Think about one person in your life right now, someone who would hear "not under arrest" and feel relief, and then go, because going seemed like the cooperative thing to do. Share this video with them today, not later. Right now before you close this tab. The question you just learned takes 5 seconds to ask, and it tells you everything you need to know before you take a single step. Next week I am breaking down what happens when a cop knocks on your door, and what they can and cannot do if you open it, versus if you speak through it, versus if you say nothing at all. The legal framework around your front door is one of the most misunderstood areas of constitutional protection in the country, and the words you say, or do not say, before that door opens, determine everything that follows. Subscribe so you catch it the day it drops. Hit the like button if this changed how you will handle the next time someone tells you that you are not under arrest, but asks you to come with them anyway. Drop a comment right now telling me whether you knew before today that voluntary accompaniment and Miranda-protected custody are two different legal situations. I read every single comment. I want to see how many people this is landing on for the first time. Know your rights. Use them. Stay safe.